Welcome, everyone. Thank you for joining us today. My name is Anna. I am the Training and Technical Assistance Specialist with the National Clearinghouse on Abuse Later in Life, NCAL. We also have a couple of folks here from the National Center who help put together these wonderful webinars. So we're just going to get started in a minute, but before we do, I just wanted to go over a few things about the platform and let you know how you can interact with the presenters throughout this discussion. The chat box will be available throughout the session, so please feel free to type in any comments or questions that you have. I will be monitoring it, as well as Kylan, and our presenters will be able to see those questions. There will be a couple times during the presentation that we'll stop and ask for questions. Feel free to use that chat box that should be at the bottom of your screen. Free to use that. And also, if you would like to raise your hand to ask a question, there'll be time at the end for a Q&A, and we want to encourage participation. Again, if your name is showing something like iPhone or iPad, any of those fun ones, if you could just change it to your name, that would be great, just so we know who we have with us today. I think everyone actually looks great from what I can see. And of course, as always, we will have an evaluation at the end. We strongly encourage you to fill out those evaluations. I'll drop the link in the chat when the time comes. Just lets us know how we did during this discussion, as well as any ideas you might have for future webinars. And I promise it takes under a minute. Really doesn't take that long, but it does help quite a bit. And finally, if you have any tech issues today, audio or maybe something's not loading for you, I am happy to help you out with that. If you want to drop a question in the chat for me, you can also message me privately if you would rather do that. And my email also you should have from the automated message that you got from Zoom. I can also put it in the chat as well, and I'm available via email. Just a disclaimer that the opinions, findings, conclusions, and recommendations expressed in these materials are those of our contributors and do not necessarily represent the official position or policies of the U.S. DOJ. And we have two wonderful presenters here with us today. Vicki and Judith are just incredible facilitators, and they have a really great presentation for you all that covers a really great range of topics surrounding jurisdiction. And hopefully you all will learn something new during this time that you can apply to your organizations or the work that you do. And we've got a couple of learning objectives that we're going to go through today. I can turn this over to Judith to get started, and we will walk through these objectives here. And I will turn it over to Judith.
Thank you, Anna. I actually unmuted myself in good time today. So thank you first very much for having me today. I hope that we will all learn together, because webinars where people are participating in these as well, because we all come to all of these with different experiences, and it's always useful to, I think, share those. I just want to do one very quick thing about my background. So, I've been a state and federal prosecutor, as well as a securities regulator and an elder justice policy expert at the, generally more at the national level, at the department at HHS, at ACL there, and I now also work as a subject matter expert in elder abuse and financial exploitation, Elder Justice Initiative at DOJ, and I'm also a senior fellow at WISER, the Women's Institute for Secure Retirement. Just so I have a very broad-based background, which is helpful when you're talking about jurisdictional issues. So I'm hoping that what I say comes to you from that perspective. So some of the things that we're going to try to cover today is looking at different kinds of jurisdictional overlaps and transitions, and the kinds of ways you can look at those jurisdictional conflicts is not conflicts, but something that could actually also be helpful to you. And maybe understanding the structure of how these different jurisdictional issues intermingle or don't, and the kinds of things that you might need to work with those. And let's also always think ahead. I'm always looking for promising types of collaborations that are going to optimize everybody's point of view, and also, and probably most importantly, that would be the best for the client that you are working. So this is, since I work in elder abuse, the Elder Abuse Prevention and Prosecution Act of 2017 has actually been very helpful. Although it doesn't have any sort of enforcement provisions, it does create an opportunity for all of us to continue to train. It says the training of agents, looking more at federal agents, but we use that at DOJ to look for training opportunities at the state and local level as well, not only of agents, but also prosecutors and victim witness advocates to learn more about elder abuse and how to proceed with those cases. It also requires data collection, which is from all different aspects of law enforcement. Unfortunately, that section is fairly vague, so we don't have as much data as I would like to have, but some data at this point in elder work is better than no data at all. And of course, better coordination between victim services and law enforcement. It created something very key for DOJ, and that is an elder justice coordinator in every single federal district. So wherever you are working, there should be an EJC on staff there, and we often have meetings just for those elder justice coordinators through different departments throughout DOJ. They are focusing on financial fraud cases. It is the largest section of elder abuse. Also doing nursing home failure of care cases and other cases related to nursing home failures. They're responsible also for community outreach. So I urge you to do some outreach to your elder justice coordinators in the district in which you work. And also they're responsible for data collection. So you can also talk to them about that. In 2020, there was a small addition to that, also promoting Alzheimer's awareness and adding further training for law enforcement and prosecutors on issues of dementia and Alzheimer's. So it's always the hardest question is like what to charge and what's the best outcome and what are you looking for? So I always focus on, who am I serving? Who is the victim? Who is the survivor in this particular set of facts? And what does that person want? What is the outcome that's desired by that person? If they can articulate it in a way that's going to be useful as you're looking at what to charge and who to include in your discussions. And also to think too, what is the best possible outcome for that person? Because sometimes you have a perpetrator that lives with the survivor, with the victim. Is separating them really the best outcome for the victim or not? We don't know. It could be, it may not be what that person desires, and how do you achieve that? And also, what is the best solution sometimes for perpetrators? Because perpetrators are often, at least in elder abuse cases, can be people who have a variety of different addictions. And sometimes a solution in cases like these can be looking for additional treatment for that addiction. It may also cause separation between victim and perpetrator, but that might be a better outcome in a particular case. And how do you achieve that, and what are the jurisdictional issues you need to look at? Also, I cannot stress enough a trauma-informed approach to both the victim and survivor, to witnesses, and to perpetrators in these cases. I think that we have overlooked for many, many years the impact of trauma on individuals. And I think that as we have also had lots of training, I think you probably have too, on trauma-informed interviewing and been able to learn how to approach each one of these groups of individuals in learning how to talk to them, and also learning how to learn from them and gain information from them and trust from them, so that you'll be able to continue in your work. One of the other things, certainly in any multidisciplinary team of any kind, is just having really sort of clear ideas of who's in charge of what. I know that may sound overly simplistic, but I worked on lots of multidisciplinary teams. I ran an elder abuse multidisciplinary team at the U.S. Attorney's Office here in the District of Columbia for 12 years. And during that time, we had all kinds of, we thought we knew what we were doing, and every now and then something would occur and we didn't have a clear guideline of who was doing what for what a particular case. So I think that's an extremely important piece. And also, it's okay to have more than one goal or outcome. I mean, there may be something that's appropriate for the victim or survivor. There may be another one that's an appropriate outcome for a perpetrator. And when you're looking at a particular case, there could be a variety of goals or outcomes that you wish to achieve, and knowing which jurisdictions and which are going to help you the most is going to be key. And who are the best members of your team to get the outcomes that you seek. So they all sound very simple, but they're all very complicated questions when you get down to it. So I was lucky enough to work in different jurisdictions where I could charge from two different groups of statutes. And that was often very helpful because you could achieve some leverage in some cases by having that two groups from which you could charge. In my case, it was a state and federal choices that I could make. It also offers you, probably most importantly, different avenues for resolution, so that you don't have to have one particular, you're not wedded to one particular type of resolution, but it can open up different ideas for that. It also gives more options for your victim or survivor as you are looking through this case to decide what's important and the best outcomes. And it can often be much more advantageous for restitution. And it gives you a few more options there and more possibilities for a more holistic response, which I think is always key in all of these cases. Sometimes in these matters, the least punitive solution is chosen. That's not always the best solution, but that is also possible. And it sometimes sends mixed signals to perpetrators of these cases. Oh, it's not so serious. They couldn't make up their mind. They didn't know what they were doing. And I find that, I found the flexibility delightful from my perspective. You also don't want to send the wrong message to people who are perpetrating bad acts. So there are all kinds of different places that you can look for aspects of approaching a case. Like, what are the types of things that are important to look at if you are charging a case or you're thinking about going forward with some sort of measures against against a perpetrator. So some of the things to look at are different kinds of licenses, professional licenses to practice or to work in some way. Sometimes discussions with the possible either taking away that license or suspending it for some period of time can be enough to somehow alter behavior in a better way. Business licenses also that require some clean records to operate. There are all kinds of issues with that related to various departments of labor, and not only within states, but also on the federal level. Also looking at what retirement accounts might have been touched or used in some way. What are the benefits? What are the kinds of coverage that are also the kinds of things that could be changed or removed? Taking somebody off of healthcare coverage might be enough to change something else, although that might not be the first choice, especially given the tentative nature of healthcare in general. But it is also a possibility in something worthy of discussion. If there's a particular rank associated with someone, a possible demotion or a sideways movement within a job can also affect things. And of course, any of these charges can affect the types of jobs that can be held, and certainly often nothing of a fiduciary nature would be available. There are, in many cases, sometimes administrative stay-away orders that are not necessarily through the courts, but they can go through a variety of administrative groups. And also there can be suspensions or probations at employment. So these are kind of different ways of looking at it without necessarily going full bore into either a criminal charge or a civil action in court. There are ways of dealing with some of these cases through administrative events that are really, I find, extremely useful, because this really does affect a livelihood very often, and that gets people's attention. So what is the federal jurisdiction? Federal jurisdiction is the overarching jurisdiction in general. It generally supersedes other laws, except as Vicki will tell you otherwise, and is used for actions generally where there's a crossing or of state lines. I used actually the kidnapping statutes as part of federal jurisdiction in some of my elder abuse cases, because people were transporting older adults across state lines for a variety of reasons. But it was extremely useful to have that available. You also have an opportunity to bring in multiple different types of investigative resources if you're lucky enough to have them. In my multidisciplinary team, I not only had civil lawyers, but I also had multiple investigative resources, sometimes from the Internal Revenue Service, in addition to my local police detectives and federal FBI agents. So there are opportunities to pull in someone, sometimes in some of larger cases from a variety of places. And you can work cases at the same time, both in the criminal context and the civil context. So that also can result in one of those investigations dropping off at some point. You can also go forward with both of them because they both have different objectives. And you can also work parallel cases doing a federal, often federal criminal investigation at the same time. A state civil investigation can be ongoing. I've done that as well. And you can apply, some of the guidelines we just looked at the Elder Abuse Prevention Prosecution Act. You can also rely on, now we're hoping, the elder justice coordinators. They've been very active in many different states and federal districts to act as not only liaisons, but also the prosecutor on the case. Sometimes they work in the criminal aspects, sometimes they work civil. It just depends on the cases. I'm a big believer that the criminal statutes allow a lot of elasticity. I was a fraud prosecutor forever and ever, and found a great deal of room to move within those fraud statutes, be they wire fraud or mail fraud or some other type of fraud, especially monetary issues. Sometimes in some federal jurisdictions, there's a monetary floor for case acceptance. We have tried very hard to not have that be the case, especially with cases involving elders, and have been quite successful in many federal jurisdictions, so that the monetary floor in many cases does not exist any longer. And what we found often with some perpetrators, especially trusted parties, like lawyers, accountants, doctors, pharmacists, people who may know older adults in groups. I had hairdressers too, for that matter, have multiple victims often. And so the monetary floor for one case may not be the monetary floor for the entire case once it's put together. Also, federal jurisdiction offers an opportunity for restitution of monies that have been taken from an older adult, and also offers an opportunity for forfeiture. I always charged forfeiture in all of my cases because we didn't know at the beginning of a case whether a victim's money was used in some way where forfeiture would be effective, but it gets the attention of everyone, and often is an extremely effective tool in returning to a victim the monies that were taken. I've had many cases where monies have been used by perpetrators to pay for mortgages or cars or something of that nature, all of which are forfeited at the end of the case because the money that was used for them was the money of the victim, and that was able to, it was in many ways a more direct and effective way to return to a victim those monies that were taken. So let's go zoom around here. I'm already behind. State jurisdictions are generally only within a state. They may have cooperative agreements with other states depending on the case. So you can use multiple state jurisdictions in one particular case if there's a reason for that. There are multi-state task forces, which I'd encourage you to participate in if they're available where you are, with internal agreements about what to charge. And some state statutes may differ from federal statutes, especially in the areas of banking and securities. They may be more useful to you because they're much more specific. But however, they can also be very restrictive. There's generally no floor in accepting a case. And the states generally have restitution, but only a few of the states have forfeiture provision. Local jurisdictions are also really interesting and sometimes really helpful in charging cases because they will follow state law, but they're also limited in their jurisdictional reach. They're very specific with regard to ordinances of one sort or another for very specific charges. They also will affect licensure requirements, back to that administrative stuff that I talked about at the beginning. So they can actually be very helpful to you in working through community issues. And they're also, I always like them because they reflect the laws and the norms of the community in which they are generally located. And also you get to know your local law enforcement and social services connections, and also financial services connections as well. So some jurisdictions have very specific restitution laws because they feel like if you are a member of the community, you've taken from another member of the community that money or those goods should be returned. So they can be extremely effective. So just a quick, I don't want to spend too much time on this, but the civil cases have a burden of proof of preponderance of the evidence, and criminal are beyond a reasonable doubt. Don't be put off by either one of those. Just keep doing your work. And civil cases are generally, I always say, fights about money. So there's generally no incarceration except in extraordinary circumstances. And criminal cases have incarceration or sometimes alternative programs, fines and financial penalties for both. The victim services are available through both venues, as are social supports. So here's a couple of cases that I did. This was a case of a tax preparer, where again, we found the first case, we had very little money at risk. And then we found that there were actually 10 victims at least, if not more. He worked for H&R Block and then went private, and then went to town. So we had offices in 2 different jurisdictions, Washington, DC and Virginia. He had victims in 3 states, DC, Virginia, and Maryland. He also had assets in not only those 3 states, but also in West Virginia. We were lucky we had one victim who was still alive at the time that we brought the case, and she was very helpful to us. We based the jurisdiction where she was and where one of his offices were. His main office was also in DC. One morning, we had quite a crew where we put together a search and seizure teams in West Virginia, DC, Maryland, and Virginia. And we went to financial institutions and other to freeze his assets, so there were no assets available for him to withdraw any further, and executed a search warrant at his home in Virginia, where we found a lot of evidence. Many of those assets that we froze were also subjected to forfeiture. And so we had a possible prosecution in 3 different federal districts, 3 different states, and 2 local jurisdictions. And eventually we brought the case in the District of Columbia, in the federal court there. I'm happy and sad at the same time to say that the judge still remembers this case. He eventually did not go to trial and chose to plead, but there were some pretty amazing circumstances given the victims who were involved. They were all single older women, all of whom he had befriended over time, and all of whom from whom he took almost all of their money. And while not harming them physically, in some sense, you're upending of your life with no money at the end of your life has all sorts of physical and psychological impacts that are not recoverable. This was also a series of cases. I called them the first of the month because it is the time when federal benefits are generally arriving at an older person's mailing address. Because many of them don't have automatic deposits, although we've encouraged that. That could be Social Security, it could be state pension checks or prescriptions. So we often found that in some of these cases, there were family members that appeared from nowhere, always generally on the first of the month. And they also went across state lines or through other jurisdictional means to use money from their Social Security and pension and to purchase drugs with some of those, or to sell some of the opioids that were prescribed for family members, leaving the older adult without enough money for food and without enough money for housing and without enough money for medical care. So we had all kinds of possible jurisdictions here with this kind of neglect. We had federal jurisdiction, tribal jurisdictions, we had state charges, we had local charges, we had the possible use of looking at extended, care and treatment of various addictions. And we spent some time trying to figure out what was the best result for cases like that. But I've had a whole series of cases of similar fact patterns. So those are some of the overlapping things. It sounds a little bit like a law lecture, and I apologize for that. But there's a lot to consider and a lot to think about. So I look forward to your question. Oh, and now always my MDT thing is like, I'm such a strong believer. I always think like, leave an empty chair. Every time you have a meeting, have an empty chair and then figure out who needs to be there that isn't there at the meeting. I think that's a good way to think about how to expand your theme, and always think big. Who touches the life of an older person, and how are you going to engage them in the work that you do, and create every partnership you can think of. And we've had great success with community members, pharmacists, dentists, bankers, grocery people. I mean, just really think, who is in your community? Who is your community that you can rely on to be helpful to you? And who are the eyes and ears of the older person with whom you work? Oh, I'm sorry. This is my financial institution list. Don't forget them. They can be great help to you. They can be a great help. They can help you work through all kinds of documents. They can help you understand what's in front of you. They're always willing to help you. I have not had any issues with any of them, and especially if you just need some help understanding what's in front of you. Community banks and independent bankers are my favorite. So that's just my personal view there. But don't forget to include them in your work. There's some good places to go, and I can add you, as many more. So hopefully that will be helpful to you, and thank you very much for listening.
Great. So I don't see any questions that came through in the chat. So if anyone does have questions that arise about...
Denise has her hand up.
Oh, all right. You are more than welcome to unmute and ask your question.
Judith, I have a question about how should cases be handled when the older adult maybe does not have capacity? If there's been guardianship that has happened, we look at trying to make everything victim-centered. I know our prosecutor here has really struggled saying that the primary victim needs to be a willing participant. But how do you suggest trying to navigate situations where the older adult really has a significant cognitive impairment and/or there was a tremendous amount of undue influence?
So I think we ultimately become paternalistic in that, or maternalistic. I mean, I've had cases like that where it's very clear that the person is what has happened to that person has been traumatic. It may not be the only thing that is causing the trauma in that person's life at the moment, but I think we have to take into account that maybe because of all those and other issues like undue influence, the decision-making capacity isn't there for knowing what the best move is. And we kind of have to, I'm sorry, it makes me crazy to do this, but you do have to step in at some point. I mean, I had to do this with one of my victims who was 94. And because of what had happened to her, our caregivers basically, mixed up her husband's medicine and he died. She was left alone and very isolated and her family was not, participatory. And she was, we needed to go forward. But what she understood at the core was that people had taken something from her that they were not entitled to take. So sometimes just reducing some of this to an ultimate simplistic kind of question that, the sort of sometimes the easy moral choice, sometimes not as easy, but, sometimes that reduction of facts and the reduction of choices is key in being able to do that. I don't know what a willing participant is. I don't think anybody's willing to do any of this in many ways. I don't, especially when you have family members testifying against others. But I think that I have yet to figure out a way around the maternalistic approach. Minimizing it as much as possible, giving as much agency as possible, giving as much dignity to an older adult is and you in each one of those cases is going to be different. But I think minimizing a lot of the noise is really helpful.
So we are going to turn it over to Vicki.
Thanks, Anna, and thank you, Judith, for the great information that you shared. I really appreciate that. So I'm going to shift to working with tribes and understanding tribal jurisdiction. And anytime I do this kind of a presentation, I like to give a disclaimer because I'm not a law trained person. Because of the work that I've done over the last 36 years, particularly working within our tribes, I've been forced to have to learn this. And as we prepare advocates working within tribes and within states, that's a critical piece of information that needs to be shared. So I am not law trained, so I'm not providing any kind of legal advice or anything like that. I'm sharing what I know and have been taught. Just want to acknowledge that I myself am Navajo and Hickory Apache, the A, that it for me is when I acknowledge that it's an important part about why this is so important to me. As an Indigenous woman, what I know through the work that I do is that often people don't have enough information. And as a result of that, sometimes what happens is harm is done. And so I don't expect people to retain everything I know. It's taken me decades to learn what I know. And the reality is that what I want people to know is enough to ask questions so that they can reach out to the appropriate resources and find the trail to get their questions answered. So for those of you that were able to participate in the webinar working with tribal communities, I talked about tribal sovereignty and the importance of it and understanding tribal sovereignty. And as a part of it, one of the things that I want to connect to it is recognizing that as all tribes are domestic sovereigns here in the United States, that they shape and define their own laws. And then there's ways that has been impacted through decisions that the federal government has made through Congress, through the laws that have been passed. As domestic sovereigns, one of the things that's important to understand is that from tribe to tribe to tribe, that the way things play out, it's impacted by the treaty agreements. So as tribes negotiated giving some of their land to the United States, negotiated the retention of their different rights that they operate within their tribes. Treaties were put in place, and those treaties are individual to the tribe as well as collective groups of tribes. And that can be important in terms of the way things will play out within their tribal lands, as well as the way they have structured their tribal governments. And the reason that's important to know is that as you get familiar with the way one tribe operates, that doesn't mean it continues over to the next tribe. So knowing that there's going to be difference, it's important to think about how you're going to how you ask the questions to know how things are different between what you know and how that's going to be different within this other sovereign nation. So one of the things that I want to talk about is the Major Crimes Act. And when we think about the Major Crimes Act, it's really important to understand how that came about and what its impact is. And so when we think about when I think about the Major Crimes Act, there's a story behind how that came about. So basically within Lakota nations, Crow Dog was killed by Spotted Tail. And we're talking about back in the like 3/4 of the way through the 1800s. And so Crow Dog killed Spotted Tail. And based on the way the Lakota people made decisions is they would look at what was lost by the harm that was done. So as a part of Spotted Tail being killed, there was a loss of support to the family. There was a loss of food. There was a loss of resources that happened. And as a result of that, the tribes made a negotiation with the families and And Crow Dog, his family, Crow Dog and his family had an obligation back to Spotted Tail's family. And as a part of that, the settlers in the area at that time were outraged that there wasn't what they perceived as a trial. There wasn't a punishment of incarceration or even being hanged. And as a result of the outcry from the settlers, the case went to the Supreme Court, which is ex parte Crow Dog, back in 1883. And so when the Supreme Court looked at this case, what they saw was that in fact, the Lakota nations had the authority to make the decisions about crimes that occurred on their land. So basically what they did was they upheld the tribal law. And then in response to that, then Congress passed the Major Crimes Act. So what the Major Crimes Act is that it basically says that in cases of rape, murder, and mayhem, that it falls under federal jurisdiction. So this is one of the first significant steps that had an impact on tribes in terms of their authority to police and hold people accountable for crimes on their land. But with that, at the same time, so as the passage of the Major Crimes Act happened, what happened was that it didn't change the sovereign authority of the tribe. So when you look at this, that when you have a major crime that occurs on tribal land, it will fall on federal jurisdiction, but it does not negate the tribal jurisdiction. So the two jurisdictions can operate together at the same time. So you have the federal authority that can prosecute the crime, and the tribal authority can prosecute a crime. So I wanted to show you this slide that breaks it down to some degree. And I also wanted to mention another Supreme Court decision that's quite significant, and that's Oliphant v. Suquamish. And this is a case that happened in 1978, so a lot more recently, where and I don't know I can't remember all of the specifics of Oliphant v. Suquamish, but the significant outcome of that was the Supreme Court basically came back and said that tribal nations do not have the authority to prosecute a non-native offender committing a crime on tribal land, which is really a significant piece in there. And then we have other legislation that's done a partial fix to Oliphant. So when we look at this chart, thinking about the impact of Oliphant and the Major Crimes Act, that if the perpetrator, the alleged perpetrator, and the victim are both native, so first line on this chart, then it falls both under federal and tribal. If we look at it where the perpetrator is native and the victim is non-native and the crime occurs on tribal land, it still is federal and tribal. But if we have the perpetrator being non-native and the victim being native and it occurs on tribal land, then it falls under federal pursuant to the Major Crimes Act. So basically the tribe, under that situation where the perpetrator is a non-native person, would not prosecute that crime, is reliant on the federal government to prosecute it. So they will start the investigation, and as a part of that, because the tribes work hand in hand with the FBI, they actually have a district operational plan. So when they determine that it is a major crime, they have X number of hours to notify the FBI, to bring the FBI into the investigation of it. And any evidence that's been collected gets transferred over to the FBI. And then again, when we think about it with when it's non-native perpetrator with a non-native victim, then it falls under state authority. So it's important to understand that, because a lot of times we think, well, this is happening on tribal land, so the state's not allowed to go in there and do any investigation, do any prosecution of a crime. But if it's a non-native offender and a non-native a victim, it's going to fall under federal prosecution. So this is just a really super simplified chart. I just want to say that because there's a lot more nuances that go beyond that. The other thing I want to mention, and I'm going to talk about Tribal Law and Order Act a little bit later, but one of the things that when we look at this particular chart, that the Tribal Law and Order Act that passed in 2010, if tribes are exercising their authority under TLOA, Tribal Law and Order Act, then one of the things that they can do is cross-deputization. And that's really worked well for some tribes. So for instance, here in Colorado, I did a lot of work with Southern Ute, and they really struggled with the boundaries where perpetrators were fleeing off tribal land and perpetrators off tribal land were fleeing onto tribal land. And through TLOA, they did a cross-deputization with the counties that surround the Southern Ute tribe and allowed for the authorities to be able to work with holding offenders accountable. So it really was a partnership that was really strong and addressed some of the barriers that happen with some of this jurisdictional challenges. So I want to talk about Public Law 280. So when we think about Public Law 280, basically what happened was that in the 1950s, there was federal law that passed. It's the 1950s was called a termination error. So it was an effort through the federal government to relinquish some of its obligations under the treaties. And as a result of that, Public Law 280, basically what it did was it was a transfer of its federal obligation to some of the states. So it transferred the federal jurisdiction to some of the states. And so one of the things that was really problematic with it was it did not consult with the states, nor did it consult with the tribes. And as a part of that, it created a lot of tension between the Public Law 280 states and the original states in the original act that passed in the 1950s. There were 11 states that were in there. So as a result of some of the early problems with it, people went back to the drawing board and they basically gave some of the states to pull the states and the tribes the opportunity to pull out of it. And so there was a little bit of a shift in some of those states. And the resource that I dropped in the chat actually goes through state by state and shows which states are Public Law 280. And when I say which states, it means that all the tribes in there will fall under Public Law 280. So as you look through that chart, you will see lines through some of the tribes. And when a line is through it is mean that a tribe is not falling under that. So for instance, in Minnesota, the Red Lake Nation is not a part of Public Law 280, while the rest of the tribes in Minnesota are Public Law 280. So what that means is that the states will investigate and prosecute the crimes occurring on tribal land, with the exception of the Red Lake Nation. And Red Lake, one of the things I used to do a lot of work with Red Lake, they talked about their treaty obligations, and that originally when Minnesota became a part of Public Law 280, because of the way their treaties were written, they were not included in that law. And so that's going to vary from state to state. Some of it's about treaties and some of it's about how they pull back later. So those of you that are working in Public Law 280 states, it's good to know which tribes are part of Public Law 280 and which tribes are not. So here's TLOA. And one of the things that's really helpful about the Tribal Law and Order Act is that the passage of it really helped provide for increased sentencing as a part of it. And when we look at the tribes and their ability to put in place consequences for engaging in criminal activity on tribal lands, there are limits to what tribes can do. And the Tribal Law and Order Act increased some of the sentencing, and it is still significantly lower than what can occur in federal court or state court. So through Tribal Law and Order Act, what it allowed for was a 1 to 3 year imprisonment or up to a $15,000 fine. So if you think of a fairly like a repeat offender or somebody that's really done some harm, but maybe it hasn't gone up to major crimes, that one of the challenges is that you still are very, very limited. And so it requires that through prosecution that there's a stacking of crimes to get a higher consequence for it, but there's still a limit of a 9-year cap when you're stacking crimes as well. So if you've got that 1 to 3 year max, and as you're stacking the crimes, if you add up those numbers, maybe it'll exceed 9 years, but the cap through TLOA says you can never go a maximum imprisonment of 9 years from any of the, from the outcome, from if somebody is convicted and how that sentencing turns out. You can't sentence more than 9 years on it. TLOA in itself is not something that blanketly all tribes are a part of. It was set up where tribes had to make the choice that they wanted to exercise the authorities that are provided through the Tribal Law and Order Act. And as a part of that, they have to provide for making sure that there's indigent representation within the courts, and that the juries are representative of the community and the offender. So for a tribe that is doing that, they need to make sure that if they've got non-natives living on their land, that jury looks like that community as a whole, and not just tribal members. And so then the tribe itself would make the decision they want to exercise this authority. They work with the Department of Justice to go through a process of implementing all of the requirements of the Tribal Law and Order Act. And as a part of it, there are other conditions that I mentioned as well as they do that. The next one is the Violence Against Women Act. And while there's multiple pieces that apply to tribes, the one in particular I want to mention is VAWA 2013. In Section 904, it authorizes special domestic violence criminal jurisdiction over non-Indians for acts of domestic violence or dating violence that occur in Indian country of participating tribes within this portion of VAWA. And what it does is it allows the tribe to prosecute non-native offenders engaged in intimate partner violence crimes. And the tribe itself has to opt into this. And again, there are conditions of requirements to make sure that the jury is representative, that they provide a defense counsel, law training, different types of obligations to it. And again, the tribe that chooses to do this works with the Department of Justice to go through the process to make sure that they're adequately prepared to implement special domestic violence criminal jurisdiction. So when you look at VAWA and TLOA, Tribal Law and Order Act and the Violence Against Women Act. So basically this chart shows you the due process requirements So defendants are provided with effective assistance of counsel. So both of them require that. Both of them require that the tribes provide indigent defendant defense attorneys for the defendant at the expense of the tribe. The defense attorney is licensed by a jurisdiction that applies appropriate licensing standards. The judge presiding over criminal proceedings are subject to enhanced sentencing, and non-Indian defendants have sufficient legal training to preside over criminal trials, as well as the judge presides over criminal proceedings. They're subjected to enhanced sentencing. Non-Indian defendants are licensed to practice law by any jurisdiction. And so when we talk about this license to practice law, not all tribes have a tribal bar. Tribes will have their own standards for how people can operate within the court system. And so what these two laws are trying to get at is to ensure that there is a licensing. So such as Navajo Nation, where I come from, we have our own bar within Navajo Nation. And I know people working in the Four Corner areas often they pass the bar across the multiple states, plus through Navajo Nation's bar and some of the Apache tribe bars, to be able to practice in the courts where the victims are coming from or the cases are coming from. So full faith and credit. Those of you that attended the working with tribal communities, I talked about full faith and credit. It is one area that has been challenging for tribes. Basically, VAWA, the Violence Against Women Act, has in place full faith and credit. And basically it says that protection orders that cross jurisdictions should be honored. And what we see with tribes is that not all tribes have the infrastructure in place to be able to enter it into the national registry. And so as such, when a tribal protection order is being checked, it may not show up in that registry. And one of our challenges as advocates is to ensure that not putting that victim to go back through a court process to get another protection order, but to work with the local system to recognize this order. And that's going to vary from state to state. We, from Redwin, we really strive the importance of making sure we don't undermine tribal sovereignty by replacing the protection order with a different one. So really take that effort and know what your process is on the local effort, the local process to do that. And what I would suggest you do is to talk to your state court administrator's office, so they can talk to you about how to do that and help take the burden off the victims. So in this process, I would just say that it's important for you to understand who the responders are. So if you're not in a public law, working with a public law 280 tribe, and your tribe is outside of that law, then you should recognize the federal presence within tribes. And with that, there's going to be a district office for FBI agents that will cover your tribes, as well as the U.S. attorney that is designated for your tribes as well. And knowing those connections are going to be important to build that relationship. Those federal partners cannot sign MOUs, but they are guided through the Department of Justice to communicate and cooperate with MDTs and CCRs as a part of ensuring the most effective and seamless responses for tribes as a part of this. So I'll just stop there.
So Vicki, I don't have a question. I mean, I have a million questions, but none for today. But I also wanted to say that there was an announcement yesterday by the Vice President about enhancing the cooperation efforts between the Department of Justice and tribes, and particularly looking at coordinating much more closely with regard to investigations and other legal issues, both civil and criminal on tribal land. So I think there may be some executive order coming out that may reflect some of that, some of the speech that she made yesterday on that.
Yeah, and that's great, Judith. I'm really glad you brought that up because they actually just started the White House Tribal Summit. And I have been working with the executive office of the U.S. Attorney for the last several years on their training team, training tribal prosecutors as well as assistant U.S. attorneys working in Indian country. And it changes with administrations, where we get guidance from the Attorney General through those trainings. We literally get memos telling all those prosecutors, you need to cooperate and communicate with tribes to make that work. So we actually are in the process of getting our current memo that we use. And so I do a lot of CCR training with that training team. And then, I'm not a prosecutor, so I've asked, I need prosecution backup on what I'm doing. And basically I get handed the memo and it's like, oh, I got the Attorney General to back me up. That's pretty cool.
Call me anytime.
I just shared an article, I just shared it twice, with Indian Country Today. It talks about the Tribal Law and Order Act, what works well and what doesn't work well. And then I am just sharing another resource from the Department of Justice about SAUSAs, Special Assistant U.S. Attorneys, which is a component of Tribal Law and Order Act, which has been really great as we've watched some of our tribal prosecutors get trained to be a Special Assistant U.S. Attorney, which allows that SAUSA prosecutor to carry cases into federal court.
Right. I would also add there's another resource also for tribes under Elder Justice Works. They're Elder Justice Fellows that are funded by a nonprofit that is Elder Justice Work through the one of the resource centers from ACL, Justice in Aging. And this year, I think we placed 4 different law students in different areas and different tribal lands across the country. If you're interested in that sort of cooperation or collaboration with another individual, contact Justice in Aging. And I think they would be able to help you find a law student who is interested in working in this. And they generally work along with experienced lawyers.
Thank you.
Great. All right. So I don't see any questions coming in to the chat box. Here are some resources that were used today during the presentation if you are curious. And thank you all, of course, for joining us today. I'm going to drop the evaluation link in the chat. If you could just spend a minute filling that out, that would be super helpful. And a huge thank you to both of our presenters for that wonderful webinar